Counsel, is this a first setting for your client?
It is, Your Honor.
All right, where are we on discovery?
The discovery's been made totally, I mean, I've had access to it. And so there's no issues with discovery.
All right, state, did you tender an offer?
Yes, we have, Judge.
All right, Ms. Ferguson, I need a plea deadline date. Sir, how old are you?
39.
All right, and these are third-degree felonies in state jail?
So 2 second degrees and 1 first degree habitual as their.
Oh,
I'm
yeah,
sorry,
I don't-
third degree habitual, I'm sorry.
okay, I'm sorry. I don't have your indictment before me, so I don't know if it's habitual or not. So, let me see.
So to clarify, it's 2 state jails enhanced with the TDC sentences to second degrees and 1 third degree enhanced
Enhanced
to
to-
habitual.
Habitual.
As a habitual. All right, we're going to recall this in 30 days. That will be your plea deadline date. If you don't reach an agreement on that date, then your next date will be a jury trial date. All right, I need a 30-day plea deadline date on Ochoa.
February 19th.
All right, and counsel, if you'll do an acknowledgement of discovery.
Okay.
All right, then after that, you're excused. Do you have any questions? All right, we'll see you then.
Thank you.
Thank you, Judge.
Let me put this- Martin Mendez. All right, do y'all have an acknowledgement of discovery? I'm sorry, not an acknowledgement of discovery, a trial court certification?
No, Your Honor, I just been appointed this morning, a few minutes ago,
Okay,
on his case. It's an MTR.
all right. Ah, because he's the Spanish speaker, correct?
Correct.
You're on this side. Yeah, this is a Spanish speaker. Oh. So next time he's before me, I need an interpreter. All right, this was actually set for a contested hearing. This is going to be recalled for a contested hearing in 10 days.
All right.
And the violations, you've now had a chance to review those.
Right.
So recall this in 10 days for a contested hearing. January 26th, state you need to be prepared for a contested hearing. All right, thank you.
Oh, I'm out of county judge in another case previously said.
I'm sorry, what?
I am out of county, Kerr County, on a previously said case.
All right, Ms. Ferguson, he needs another date.
If I can have the 29th.
All right, 29.
Thank you, Judge.
Thank you. Damian Antonio.
Right here, Your Honor.
And that's a PTD.
It is, Judge. You got the contract?
Damian Antonio, come up, please. And has the contract been completed?
Yes, we just signed it today. They changed the procedure a little bit. They want us to scan and email it. So as soon as we get back to the office, I'll have it over to them within the hour.
All right, I need a PTD date.
I can do, February 19th.
That works.
All right, we'll see you back on February 19th. Once you sign the reset form, you excuse.
Good deal.
Thank you.
It's okay.
All right, Rita Panana. Good morning. All right, court is calling 2025 CR 010639, State versus Rita Lisa Pineda. All right, could I have parties announced for the record, please?
Lauren Espinosa for the state.
Ray Lopez for the defense.
And are you Miss Pineda?
Yes, I have.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Pineda, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Judge, I agree.
Your charge is possession of a controlled substance, penalty group 1, less than 1 gram.
This is the plea checklist in action. Judges go step by step for a reason to lock in that the plea is knowing and voluntary. Once these boxes are checked on the record, reversing a plea later becomes extremely difficult.
That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Panetta, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Judge.
Anyone promised you anything other than the plea?
No, Judge.
Are you satisfied with the way you've been represented?
Yes, Judge.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Judge.
According to the plea, punishment is to be assessed at 221 days in the Bexar County Jail.
Yes, Judge.
Under 1244, there's a $600 fine and there are no applications. Did you understand that to be your plea? Defense?
It is, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I did, Judge.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Judge. I did.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. State offers State's Exhibit 1 in all attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge. I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Judge.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We would ask the court to follow the plea bargain agreement, Your Honor.
And to the clerks, how much time does she have in?
She's
Okay. I'll find out how much time you have in. What I can tell you, I'm assuming that you all are asking that this be a judgment satisfied.
Correct, Your Honor.
This is what I can tell you.
This moment trips up a lot of defendants. Jail credit isn't controlled by the judge, it's controlled by the jail. Courts sentence in days, not deals. If the jail changes how credit is applied, the judge can't fix it later.
If I follow your plea bargain agreement, which I will sentence you to 221 days at the Bexar County Jail. If you're assuming you have a judgment satisfied because you received 2 for 1, or you're trustee and you're receiving 3 for 1, so for every 2 days in general population without any problems, for every day you receive the credit for 2 days in general population, or if you're a trustee, for every day you will receive 3 days. This is the thing about that. I'm not in charge of that at the jail. So the jail can make the decision that they're not giving you 2 for 1. What I can tell you is I'll follow your agreement. You'll be sentenced to 221 days. So once I sentence you, if the jail is not giving you 2 for 1 or 3 for 1, I have no authority to force them to do that for you. You understand? So does she have 221 actual days in or no?
No, Judge. She has 130.
So that'll be up to the Bexar County Jail. All right. So as previously stated, the court will find you guilty. The court will sentence you to 221 days in the Bexar County Jail under 1244. Give you credit for any time served. And there is a $600 fine. Time and money will run concurrently. Anything else with regards to sentencing?
That's it for the defense, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, and because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
I do.
All right, we can go off the record. Here's the thing. It appears that you may have a drug problem. And this is sort of the easy way out. You take your time and you're done. When you're released, what you need to do is you need to find some place to do sober support meetings. Those are like your NAAA meetings. They're all over the city, all hours of the day, so you can take it at any time. Because if you continue the way you are, either you're going to be back before another judge, it may not be me, it may be somebody else with another attorney, or either the last time you use may be the last time you use, and somebody's going to have to identify your body. You understand?
Yes.
If you can't find a place to go for a sober support living or something, if I'm still here, come back here. I'll pick up the phone and call somebody to help you, okay? All right, good luck to you. Thank you. All right, the parties on Shepherd Jepson, did y'all do are you all proceeding on the motion to revoke today?
I'm going to ask for some time may approach.
Yes, have your client come up.
Judge, you'll remember Mr. Shepherd.
Mhm.
Judge, we're requesting a 1-week reset. We have some proposed resolution to the case with Ms. Albon that would send him to the intermediate sanction facility. He has a couple of pending pre-filed misdemeanor cases in County Court 12. So I've been going back and forth this morning. We're going to waive certain things. We're going to file the cases, and we're set for a plea next Wednesday on the 21st. So we'd ask just that you recall this case next Wednesday. That would,
to be on a Thursday.
well, but that's fine. The 22nd would be fine too, Judge.
Ms. Abrams, on this case, can you see if there are any openings in felony drug court?
Yes, Judge.
And so and how long would it take for them to interview him? All right, just give us a moment. I'm going to see how long it's going to take felony drug court to interview him, because it may take longer than the time that you want to be back.
Okay, Judge, thank you.
All right. And then,
Yes, ma'am.
yes, Mr. Shepherd. So here's the thing about felony drug court. Depending on what happens with your case, I keep an open mind on everything, but it appears from looking at the MTR, there are some issues. So if you're accepted in felony drug court, and you may want to call over there, they will make the determination if I were to send you there, whether you go into inpatient at ISF or not.
Okay.
Now, what I can tell you, if I order felony drug court and they don't accept you, then more likely than not, you're going to go to an inpatient facility. Do you understand? So you all need to reach out for that. So just have a moment. Ms. Abrams is going to find out when they can interview you. Thank you. Andreas Hernandez, if y'all will come forward. Raphael Liel.
How are you, Judge?
Oh, I'm doing great. How's it going?
Excellent.
Yeah.
Hello, Your Honor.
Hello. So where are we on discovery on this case?
I have the discovery, Judge, and I have discussed the matter with the prosecutors. I have gotten an offer, conveyed the offer to Mr. Hernandez, and recommended that he take the offer, but Mr. Hernandez is of a different mind and wants
Well, I
to
mean, here's the
set
thing.
it trial.
If you want a jury trial, we will give you a jury trial, and we will give you a jury trial quick, fast, in a hurry. This is a possession case, so it shouldn't take that long.
Yes, yeah, and I understand. I know if I take it as your trial, that would be 25 plus years if I were to lose. That I understand. I feel as if I don't have to go to that route, thinking I know I'm not gonna beat the case, but I feel my constitutional rights were violated.
Okay, so let me stop you there. Here's the thing. With drug cases, right? If your attorney wants to file a motion, the court will hear whatever motion they file. Now, in my experience as a defense attorney and prosecutor, with regards to drug cases, sometimes people complain because there was a search warrant. They say the search warrant was improper, right? So that's something maybe you can file a motion on. Sometimes you have people who maybe were driving a vehicle pulled over by the police, and you say the police never should have pulled me over. And I'm just speaking to you in layman's term. And that may be a reason, right? So those are usually the reasons for people are saying my rights were violated. Now, drug cases normally, and yours normally, would probably be, what is this? A third-degree felony with a range of punishment of 2 to 10 years in prison. But if you are designated as a habitual and the state is able to prove up that you're habitual, now how do they prove that up? Usually, you know what it ends up being? They have somebody send what's called a PIN packet. And the PIN packet is a packet that has documents in it that will show that you were sent to prison or something before this case, right? So if that has happened twice before this case and the state is able to prove it, then that means you're designated as a habitual. The law changed back in the day. Didn't matter how many times you had been to prison, you wouldn't be designated as a habitual.
This is where reality hits hard. Habitual status removes mercy from the equation. No probation, no suspended sentence. A jury conviction here doesn't ask how bad, it asks how long. And the floor is already set at 25 years.
But all around the country, they started doing this 3 strikes and you're out thing, right? So with you, instead of your range of punishment being 2 to 10 if you were found guilty, your range of punishment is a minimum of 25. So that means if you go to a jury, if a jury were to find you guilty, they can't give you probation if they find that these allegations are true. Your minimum is 25. If you come to me for a bench trial, and what I can tell you, I've had bench trials before me where I found people guilty and I found people not guilty. If you come before me and you're found guilty on a bench trial, I can't give you probation. Your minimum is 25. And I know sometimes people are like, oh, it's just a drug case. I can't believe I'm getting 25. But that would be your range of punishment. It's completely up to you. So for your case, we'll set it for a jury trial.
Like I was gonna say, it says here that I was found with what 1 gram. I had 3.2 grams.
Oh, no. So here's the thing. You don't want to let or admit to things. You're not under oath, so you'll be fine. But this is what I can tell you about your case. Could I see the indictment on Andres Hernandez, please? They're putting you at a 3rd-degree felony because according to what I'm reading on the docket, it may be wrong. That's why I'm asking her to pull the indictment. You were in a drug-free zone.
That was on the sidewalk.
Yeah, here's the thing though, but drug-free zones, like schools are usually drug-free zones.
Yeah.
So if you're within a certain feet from a school, so that means that maybe if you have a possession less than a gram, it's no longer a possession less than a gram. They enhance it because you're in a drug-free zone. And when they enhance it, it becomes a 3rd degree, you become a habitual. Your minimum is 25. Now, if it's just a regular state jail felony drug case, then you're most likely looking at 2 to 20 years unless there's something else out there. So that's where we are.
So that's 44B doesn't work on this one either, right?
They're not, no.
Nothing like that.
No.
44, nothing like that. Okay. Well, when they arrested me that day, it was San Antonio Independent School District Police. They
You're
called.
allowed to do
They
that.
called that San Antonio Police Department twice, and they never showed up. So they took me to their facilities, and they took my wallet from me. They took my credit card. They took my money, and they put it inside my backpack, and they kept it in their facility. And to this
You
day,
don't have it.
to this day, I'm unable to keep my money. I'm unable to keep my credit card because.
Okay, let me explain something to you, and I want you to internalize what I'm saying.
And I thought it was a
No.
violation of the 14th Amendment.
All right, I want you to internalize what I'm saying, right?
Yes.
I've had clients in the past before who have told me, like they get arrested for something. Let's say they get arrested for a drug case, right? And my client would tell me, hey, Stephanie, the officer roughed me up. My case should be dismissed. They think it means it's a wash. And I tell them, the fact that an officer maybe roughed you up, that is a whole different case. We're just here dealing with the criminal case. So the fact that you're saying that the school division, they kept your license, they kept your credit card, maybe they took some money, that's a civil matter. It has absolutely usually nothing to do with the criminal case. You understand?
Never in my rights either.
Yeah. So that's where we are. So if you want a jury trial, I'll give you a jury trial. I'm sure your attorneys explained to you. I've explained to you what a habitual means, and it appears in the indictment that I have that you've been designated by the state. They're saying you're a habitual offender. If you go to jury trial and are found guilty, you're looking at a minimum of 25.
Okay, can I get a trial?
I'm sorry?
Trial?
Oh, sure. We'll get you your trial.
Judge, and for the record, the offer that I conveyed to my client was,
Oh, I don't need to know the offer. If you want to put the offer on the record, you can.
yes.
All right, just go ahead and go over there and yes. And I'm sorry, what page is he on again? Yes.
Felony drug court said that as long as they get the referral today, we could get him scheduled for interview on Tuesday. We just need to make sure that he is available.
I'm available, yes, ma'am.
All right. So this is what we'll do. And counsel, when did you say those other cases will be taken?
We're gonna enter those pleas in County Court 12 on the 21st, which is Wednesday, I believe.
All right, so Ms. Abrams, if you let them know that they're gonna do that at that time. And I'm sorry, let's go off the record briefly.
Thank you, Judge.
You're welcome. And counsel, I'm assuming you're waiving the contested hearing?
Yes, Your Honor.
All right, who's next?
The last page, Judge. The add-on page, add-on question.
Arsenio. Morning, Judge.
Hi, good morning.
Yeah, we added on to potentially come in here and talk about maybe doing a plea. But it didn't work out, so we're fine with our trial setting.
Okay, let me see. All right, Mr. Marcinak. All right, so my understanding is that y'all were unable to reach an agreement?
Yeah.
All right, so the plea deadline date will have expired. The court will not consider any plea bargain agreements without good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes, ma'am.
All right, then my next thing is, do y'all have an acknowledgement of discovery completed?
I believe so.
We did one today. Yes, it was part of the, we were trying to work out that we can use that one, I guess.
I think we already did it when we got our trial setting.
All righty,
Right, thanks, Judge.
thank you. Once you sign the reset form, you're excused. I know you have a previous one, but
And we can use that one unless the court.
no, all right, see you then. Anyone else ready?
Sure. Did you want us to sign in the new one or use the old one?
I mean, whatever is easy, they're in the system. It may be easier just to sign it. All right, who's here on Gerardo Nunez? Thank you.
Good morning, Judge.
Good morning, how's it going?
Good, how are you?
Oh, well, other than the computer being down and then not being able to get into Odyssey when they redid things, but other than that, great.
And we're halfway through the month.
Oh, yeah. Isn't that hard to believe?
I can't believe it.
Okay, let me make sure this goes on. Good morning.
Good morning.
All right, the court is calling 2025 CR 005653, State versus Gerardo Nunez Jr. Can I have parties announced?
Brandon Brady for the state.
Alma Benavides for Mr. Nunez.
And are you Mr. Nunez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
And to the court, what page is Nunez on?
Page one.
Page one, Judge.
All right, thank you. All All right, Mr. Nunez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Nunez, did you review the court admonishments with your attorney? Did you understand it and sign it on all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
All right, we're off the record. I've received a rejection, but the rejection has this cause number on it.
The cause number, excuse me, Your Honor.
Sure.
Should be 2025 PF 50990.
Indeed, it should be.
All right, so if y'all would correct that.
Yeah, give me just a quick moment, Judge.
Sure. Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do. Your
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Nunez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No,
Anyone promised you anything other than the plea?
no.
Are you satisfied with the way you've been represented?
Yes,
If you're not a U.S. citizen, by entering into this plea, you will be deported, denied naturalization, and reentry. Did you understand?
yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's $1,000 fine. State is asking that 500 of that be probated. There's no application for community supervision. The state recommends deferred adjudication. They're taking in consideration 2025 PF 50990. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State, is that the plea?
Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There'll be 200 hours community service restitution, parenting class, cognitive thinking course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No,
State any evidence.
Judge, we offer exhibit number 1 and all of its attached.
We reviewed them, Your Honor. No objections.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we're just asking the court to follow the plea bargain agreement. Mr. Nunez is gainfully employed, and he has indicated that he is willing to comply with any conditions the court would impose.
All right, so here's my question. What do you do?
I'm a public pro for Amigos County.
Okay. And who is Miss Carrillo to you?
Yeah.
Yes, the person who was in the vehicle with you, the adult. Jeanette Rio
yeah, that was my girlfriend.
was.
Yeah.
And the 8-year-old who was in the vehicle, was that your son?
Yes, ma'am.
And so where's his mom?
That's
Oh, she's your girlfriend,
Yes.
but she's your ex-girlfriend.
yes.
All right. So has Child Protective Services been involved in your life? So do you live by yourself or with someone?
With my mom.
And are there any children in the household?
No.
All right, this is what the court will do. There's $1,000 fine that will be probated. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 40 days. There's to be no employment as a home health care provider or with minors. Field visits 1 time per month until further notice. 3 years. Deferred adjudication. 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. TAP evaluation out of custody. If you miss that TAP evaluation, a motion to revoke is going to be filed.
Yes, ma'am. I'm
How often had you been using?
it was rare. It's like
Here's the thing, now's the time to tell me the truth because I'm trying to set conditions that will mean that you will be successful.
a year or two.
I'm sorry, what?
A year or two.
No. How often had you been using?
Like,
Okay, so-
daily, like,
Yes.
I'm guessing, yeah, daily.
All right, there's going to be sober support meetings, 90 and 90 days. And the life skills course. Probation, is there anything else? Is there anything else you need in order to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Understand.
All right, we can go off the record. In this court, communication is key. If there's an issue, you need to let probation know about it. If you feel that they are not addressing it, you can always come back to the court and address it with me.
All right.
All right, good luck to you.
I appreciate it.
Thank
All
you,
right, thank you.
Judge.
Thank you, Judge.
Welcome. Danny Rivas. All right, he's scheduled for a jury trial on, I have him down as a jury trial for January 25th. Why is he here?
That's a. I think you meant 15.
Oh, okay. Oh, yeah, I see the correction in the system. So, jury trial,
Yeah, Judge.
what date?
Whenever the court's available.
How long do y'all expect this trial?
I don't think longer than 2 or 3 days, including jury selection.
All right, number 2 days.
I can do March 17th.
We do a little sooner than that, Judge, just because I think I'm on vacation from the 15th through the.
All right, I need a date before then.
I can do February 23rd.
February 23rd.
That works, Judge.
All right, so we'll come back on February 23rd. That will be your jury trial day.
Thank you, Your Honor.
Thank you.
Yes.
Samuel Ramirez.
Good morning, Judge.
Good morning. Oh, this is a motion to revoke?
It is, Judge.
Where's the motion to revoke? Okay. I know you're doing a lot. Samuel Ramirez.
Wow.
All right. Yes.
We're ready to go forward with a plea of true to number 2, alter and amend. Court's
All right.
kind permission.
Court is calling 2023 CR 6620 State versus Samuel Alexander Ramirez. Can I have parties announced for the record for the state?
Rick Pena for the state of Texas.
Michael DeLeon for Mr. Ramirez.
And are you Samuel Ramirez?
Yes, ma'am.
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Samuel Alexander Ramirez, who's placed on deferred adjudication in 2023, CR 6620, for the offense of possession of a controlled substance penalty group 2, less than 1 gram in a drug-free zone on November 29, 2023, for a term of 4 years. Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, violation condition number 2. On or about the 11th day of July, 2025, in Bexar County, Texas, the defendant, Samuel Alexander Ramirez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
State.
State will waive the other violation, Your Honor.
Any objection to the waiver?
No waiver, no objection, Your Honor.
Right. Did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, there is, Your Honor. That is to deny the state's motion, alter and amend his conditions of probations to add supportive outpatient treatment, as well as amend to require the defendant to provide proof to probation that he is regularly attending his mental health therapy classes.
That is our agreement, Judge. We do have his parents in the courtroom today. We do have proof that he is going to mental health treatment. Additionally, the reason for violation condition number 2 that he missed, he's had 4 surgeries. Show the judge your hand.
Yes.
He had a workplace injury. So in June or July of that last year, he was recovering from his 4th surgery. And that's the reason why he did report. So that drug testing. So we're asking the court to follow that recommendation. Otherwise, he's been doing well with his probation officer, and he's kept his probationer advised of everything that's been going on.
And the other allegation in the motion is taken care.
That's going to be going away from my understanding.
All right. And could I have the parents come up?
Sure. Mom, Jack.
Yeah. Thank you.
Hello. Good morning. I'm doing great. I know that he was doing so well because he was on GPS. I removed that. So how are things going with him? With the mental health, is everything all right with that? Or did the injury sort of call him to get off track?
Right. So the injury, I wouldn't say that it put him off track. I think it kind of elevated the mental condition that he currently had. Like I was telling his attorney, he now is newly diagnosed with PTSD due to the traumatic event that occurred at his workplace. It did occur when he was 19. So a little bit after he left seeing you, a few months, he got a job. He sustained employment, continued with school, graduated as you wanted him to.
Okay, awesome.
Yes. So he did do that, but then the injury occurred. And to be honest, he's been in and out of the hospital since that injury. He's still going to see his mental health doctor. This time, it not only was it due to the ADHD that he's been diagnosed with, but he started feeling a little different. And he sought treatment on his own to discuss that. And so at that time is when the doctors determined that he does have PTSD, and it's elevated almost as a war veteran. And oh my God, I feel like I have PTSD.
So let me ask you this.
Yeah.
So, of course, I'm not going to revoke him. I'm going to deny the motion.
This is the human side of the courtroom most people never see. The judge isn't excusing violations. She's deciding whether punishment or structure gives the best chance at compliance. This is discretion in action, and it doesn't happen often.
But I'm trying to figure out what does he need from the court or what the court can give him. I know he'll need to continue with the mental health treatment, and that should probably be at the forefront of things that he needs to do. But then they're telling me sober support meetings as well. So is there a drug issue going on as well or no?
No, he was missing because of the surgery. He's been in multiple surgery from insurance. I'm around this one, but.
Okay.
Several on voice, but,
problem.
a lot has changed for him since the last time I saw him. Now, surgery, and now he's a dad.
He's a dad also. He's a single dad, by the way.
I watched the first time on that, so he's doing it on track. Just, I wasn't. I think on that time when he had surgery, and of course, his probation knew about it, but I wish he was here to talk about it, but.
Well, I always tell everybody, if there's an issue and probation is not addressing it, I'm on the bench, you can always come in. You wanted to say something?
I just wanted to bring it to your attention as far as why that was recommended is because when the defendant originally pled and had submitted to his TAP evaluation, that was the recommendation as a result of the TAP evaluation, but it never was placed on his conditions of probation. So we're just asking that to be placed. Now that's the supportive outpatient treatment.
Probation?
Yes, Judge.
Let me ask you, in this case, do you think it's best to make sure we address the mental health? The parents are telling me that he hasn't been using drugs, doesn't have a drug issue. Maybe we can do the random UAs, and then if there's a positive, then we go to supportive outpatient.
Yes, Judge. That sounds good.
Okay. Is there anything else?
Oh,
All
yeah.
right, thank you. And here's the thing. Let probation know in this court, what I can tell you what ends up happening. If somebody falls off track, you call probation, let them know about it. Unless it's something that's considered egregious, I'll usually set it for a compliance hearing. We come in, have a conversation to see if they can get back on track. And this is one of those cases where all he needed to do, contact them. If they're not answering, he could have just came back to court and would have had a conversation about it, okay?
Yes, ma'am.
All right, thank you so much for coming
Thank
in.
you for your time.
All right, thank you. All right, Mr. Ramirez. How's parenting coming along for you? Yeah. Yeah, people always tell me the babies have new eyes, so everything is new to them, so then it makes it new for you. All right, so the court will deny the motion. The court will alter and amend conditions, and you're to continue with your mental health treatment. And probation is going to continue with UAs. And here's the thing, make sure you stay in contact with probation. And if for some reason you have an issue and you feel as though probation is not addressing it, come back in here on a business day, of course, not on the weekend, because I won't be here. I'll probably be here, but nobody else will be. So just come back, talk to me, and we'll figure out what's going on.
Okay,
All right, but keep up with the great work, okay?
thank you.
All righty.
We appreciate it, man.
All right, thank you. Have a good one.
Thank you, Judge.
Thank you.